You're listening to the Patenting for Inventors podcast with registered patent attorney, Dr. Adam Diamond, founder of Diamond Patent Law, the #1 source for securing your intellectual property needs. Now, here's your host, Adam Diamond.
Hello and welcome to the Patenting for Inventors podcast, episode 107, the top 10 patent acronyms. My name is Adam Diamond, a registered patent attorney and founder and owner of Diamond Patent Law in Los Angeles, California. I can be contacted through my website at diamondpatentlaw.com. That's DIAMENT, patentlaw.com, or call me at 424-281-0162. I'm going to take a little break from talking about patent litigation to do a short episode about patent acronyms. If you're talking to a patent attorney or you're reading about patents, lots of times you'll come across acronyms and no one will bother to explain what it means because they just assume you know. And I hate it when someone's talking and they start using all these acronyms, and I think because they're saying these things that I'm supposed to know what it is, and I'll feel stupid if I ask. And then I try to look it up later, but then I look it up and there are 20 different things that have the same acronym and you don't know which one they're talking about. I've probably done it in my podcast and don't realize it, or maybe I said it in the first episode, but if you're jumping around in the podcast in a later episode, you might not know what I'm talking about. So I'm going to go over what I think are the top 10 acronyms you'll hear patent attorneys use. The first one is IP. This one gets used so often that I almost forgot to include it. IP stands for intellectual property. Intellectual property are the types of creative things that you can protect as part of your property. The four main kinds are patents, trademarks, copyrights, and trade secrets. Someone may just call themselves an IP attorney and do all of them, or they might just do one of them. They might do litigation, or maybe they do patent prosecution. The second one is kind of a double. It's PTO or USPTO. The USPTO stands for United States Patent and Trademark Office. This is the government agency where you file your patent application and it gets examined, and it's the agency that issues your patent. It's physically located in Alexandria, Virginia, which is pretty close to DC, but most of the work is done electronically, so you don't have to go there for most things. Because the acronym isn't short enough, we've shortened USPTO to PTO, which just stands for the Patent and Trademark Office. Number 3, MPEP. This stands for the Manual of Patent Examining Procedure. This is a huge book, and it got so big that now it's 2 books that are each telephone book size. And it's about the procedures for filing and examining patents. You could think of it as each of my podcasts, where maybe they were 10 minutes, expand each of those 10 minutes into 100 pages. It has all the rules about the patents that the PTO uses. Number 4, PHOSITA. This stands for Person having ordinary skill in the arts, PHOSITA. I talked about PHOSITAs when I talked about obviousness. Remember, you can't get a patent if your invention is obvious, but obvious to whom? Maybe it's obvious to the smartest, most inventive person in the world, but not obvious to a 4-year-old. The PHOSITA is supposed to be a standard that obvious is judged against. It's an ordinary person in the field in the technology where you're filing a patent. So if you're filing a patent on a new mechanical pencil, the PHOSITA might be someone that has a mechanical engineering degree and a few years experience in the pencil world. It's a hypothetical person that doesn't exist. You can't say, I know a mechanical engineer in the pencil industry, his name's John Smith, and I asked John Smith if this was obvious, and he said it's not obvious. Now, it's useful to know that information, and you could probably use that in some way, but there's not a particular person you can point out and say, this is the PHOSITA that you're supposed to judge obviousness against. It's a general category of person. Number 5, PTAB, PTAB. This stands for the Patent Trial and Appeal Board. If your patent gets rejected a couple times by the patent examiner and you want to appeal it to a panel of judges, instead of having to try to convince the examiner of patentability of your invention, you appeal to PTAB. And they can make rulings that override the patent examiner, or maybe they'll agree with the examiner. But this all happens at PTAB. Number 6, CAFC. This stands for the Court of Appeals for the Federal Circuit. This is a federal court where mostly patent matters are heard. If you don't like the outcome of what happened at PTAB, you can appeal again to the CAFC. Also, if you have a trial court about a patent, such as patent infringement, the initial trial will happen at a local federal district court, and when you appeal it, it won't go to the First Circuit Court of Appeals or the Second or the Third Circuit Court of Appeals. That's where most federal appeals happen. They go in the region where you're located. But if it's a patent case, you appeal to the CAFC. And if you don't like that decision, you can appeal to the Supreme Court. Number 7, EPO. This is the European Patent Office. There are probably acronyms for most of the patent offices throughout the world, But because you can get a single European patent that can cover lots of countries, around 40 or so, I think now, the EPO is a pretty important one. It's like the USPTO, but for Europe. And if you ever want to patent in a European country, you're probably going to be dealing with the EPO. Number 8. PCT. PCT stands for Patent Cooperation Treaty. It's a treaty that most countries throughout the world are part of, where there's lots of coordination regarding patent filings. You can file one patent application with a PCT office, and then it makes it easy for any country that's a PCT member to look at what you filed and use that as part of your application, or sometimes your application in whole. I talked a lot about PCT applications in this podcast. If you're interested in any type of foreign patent protection, you probably want to file a PCT application. Number 9, WIPO, W-I-P-O. This stands for the World Intellectual Property Organization. It's an agency of the United Nations, and currently 193 nations are part of it. It's an organization that was made to create and promote intellectual property around the world. And when there are treaties between lots of countries regarding intellectual property, such as the PCT that I just talked about, WIPO is going to be heavily involved with that. Number 10, the last one, USC. I'm not talking about the Trojans here. I'm talking about the United States Code. This is the official compilation of federal statutes of the United States. It's the United States Code where the law says that you can't patent something that isn't new, isn't useful, or isn't or is obvious. I talked about various sections of the United States Code before. If you get a patent rejection and it says rejected under 35 USC Section 101, it means you can't get a patent because it's not patentable subject matter, like you're trying to patent a mathematical formula. If you get a 35 Section 102 rejection, it means that your invention isn't new. If you get a 35 Section 103 rejection, it means your invention is obvious. This is because it's those sections in the United States Code that actually say what is patentable and what isn't patentable. Usually patent attorneys will shorten it even more and not even say 35 USC Section 101. They'll just say, I got a 101 rejection or a Section 101 rejection. I'm sure there are lots more acronyms, but these are the top 10 that I thought of. I think these are the ones you'll probably encounter most if you're ever looking into patent issues. And if you want help with your patent application, trademarks, copyrights, responding to rejections, appeals, or anything else related to your invention, you can contact me directly through my website at diamondpatentlaw.com. That's DIAMENT patentlaw.com, or email me at adam@diamondpatentlaw.com, or call me at 424-281-0162. I'm Adam Diamond, and until next time, keep on inventing.
Thanks for listening to the Patenting for Inventors podcast with host Adam Diamond. If you enjoyed the show, please rate and review on iTunes. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information and help with your own intellectual property needs, contact Adam Diamond at patentingforinventors.com. That's patentingforinventors.com, or call Diamond Patent Law at 424-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.